Simply put, today's own was what we call a contempt application. And when we say contempt application, is an application that Ashgold, Sporting Club has brought to court with the aim or with the intention of citing the respondents, the Executive Council and one other person to prison. And today started the formal hearing of that contempt application. And basically what happened in court today was that the judge realized that the documents filed for and on behalf of all the respondents, particularly the 1st to the 13th, according to the court, was not correct or was improper. Why? Because the court was of the opinion that this is a quasi-criminal matter. And when we say it's quasi-criminal, what it means is that the end results could be either you are being fined, you be an ex-convict, or you can be imprisoned. So each person must file his own documents, to respond to the charges. So what Ashgold Sporting Club has brought, by way of the contempt, is what we call charges, against the Executive Council and one other person. And so the court has adjourned to 25th of October to enable each and every one of them, there are 14 of them, to respond to the charges leveled against them individually, and not collectively. Then, quite apart from that, the court was also of the opinion that the fifth respondent, that is Dr. Randy Abbey, he has been able to file his response, in simple terms, individually. But the court realized that he raised issues of the service of the interlocutory injunction order on him. So the court was of the opinion that on the 25th, the contempt application will not be heard, but rather he will conduct a mini trial. When we say a mini trial, it's a trial within a trial, to ascertain whether or not the order for interlocutory injunction, which formed the basis of the contempt application, was actually served on GFA through Dr. Randy Abbey. And so basically that was what happened or transpired in court today.
And tomorrow you guys are back again?
Yes, for the injunction. Yes. So yes, supplementary. Yes. So as I disclosed to the other journalist, we have two separate actions now in court. We have what we call the originating motion on notice on one side, on which we have put the injunction. So the injunction is not on its own. There is a background case to the interlocutory injunction. What it means is that, after the injunction has been heard, the main murder case itself will now have to be dealt with. That is on one side. Then we have the contempt application, which deals with what we call violation of an order of court, which applicant Ashgold I would have to prove to the court beyond reasonable doubt that indeed that is what happened. So that is also another side. So the public or the journalist must know that there are two separate courses of action that we are dealing with in court at the moment. One deals with what went on in the GFA disciplinary hearing, which Ashgold is coming to court to challenge, and the other deals with the disobedience, the alleged disobedience of the order of the court, also on another side. And that is why we are in one court, before a different judge, and we are also in another court before a different judge, even though both of them are human rights court.
And how long are we looking for this whole case to last?
Yes, we cannot actually predict in each case, because court deals with rules and then procedure, and also the conduct of the lawyers, the parties, all right, and the court all comes together to determine when a matter will be heard and determined. But it has always been the law that courts would have to hear matter, speedily and ensure the delivery of justice within time. Everything in the courtroom is regulated by law and procedure, okay, and both lawyers and their parties and the courts are aware. So prediction at this moment will be very difficult, okay, but the court is enjoined by law to ensure that there's always speedy, trial, so that, justice will be done to the parties in accordance with the law and the procedure. Thank you very much, okay.